Representing the appellee, the state of Vermont, is attorney Zachary Martin.
All right, thank you very much. Counsel for the appellant, please introduce yourself and your client, and then you may proceed.
I'm Sarah Starr, and I represent the appellant father, JC. Father and AC had an established and loving bond. The evidence showed that AC would cry at night for her father, asking, "Why can't I have my daddy? Why can't I have my daddy?" And why couldn't she? It is true that father struggled significantly earlier in this case with mental health and substance use. But in 2024, something amazing happened in that he received a life-changing diagnosis and he started treatment, and he testified that he loved his treatment. He felt amazing. He loved going to therapy. He loved taking his medication. And there was absolutely no reason why the state could not begin to reunify at this point, because the child still didn't have a permanent home. The father was clear that after years of suffering, he now could parent, and he was committed to doing whatever it took to be a part of his daughter's life. More than that, he knew he could do it. He testified unrebutted that he was doing great and that he knew that he could now be in a position to parent his daughter. In an astounding twist, the court used this very belief, his own belief in himself, to terminate his parental rights and determine unfitness. The court stated, "Father's belief that he can resume parenting once he has an apartment demonstrates how little he knows about his daughter." Father's parenting qualification, that he was actually her parent, was nothing at all to the court, and it was treated as less than nothing. Meanwhile, there was no evidence, zero evidence, about this family that AC had only very recently been placed with. All we know about them is that they have a daughter and a dog. And this is not, to the extent that there was any evidence that AC had specific trauma that needed to be remedied by having a house with a dog, this is not how you remedy childhood trauma. You don't remedy childhood trauma by abandoning reunification with a fit parent and leaving open, festering wounds. Like, we need to do better for Vermont children than just being satisfied that after, an extended period of crying for their parent, they just stop asking about them. That's not the standard. So the way to remedy the trauma, the way to remedy this family, is to attempt reunification. Giving up asking for a parent is not a good sign, and this is a no-brainer. This case needs to be reversed. Thank you.
All right, thank you, counsel. Counsel for the appellee, please introduce yourself and your client, and then you may proceed.
Good morning, Your Honors. My name is Zach Barton, and I represent the appellee Vermont Department for Children and Families in this case. Happy to answer any questions that the court may have. If none are raised, I'll just briefly touch on some points that support affirming the judgment below. So when the overall timeline of this case is considered, it's clear that it is not a close one. By the time of the termination hearing, the child at issue was 5 years old and had been out of the home for almost 4 years. Father had not had an in-person visit with this child since 2022. And so the trial court properly considered that long absence from the child's life, both as a past circumstance that affected their parent-child relationship and a factor that was relevant to whether father could timely resume a full-time caregiving role over the child. So father would have this court ignore this larger context and focus only on the last couple months of the case. But even within that narrow time frame, father was not completely compliant with the expectations of the case plan. For example, he was directed to regularly meet with a counselor as part of outpatient mental health treatment, but he failed to attend those sessions consistently. These cases are difficult. They often require the trial courts to make difficult predictions about the future. But when those predictions are based both on past events and current circumstances, they don't amount to discrimination. And nothing in the trial court's order shows that it was in any way biased against father. The record as a whole shows the contrary. The court took great care to protect father's rights throughout the case, delaying termination to ensure that father could fully participate. This first occurred in January 2024, when the court bifurcated father's case from mother's. It occurred again in September of 2024, when the court, this time over the department's objection, again delayed the termination hearing to allow for the appointment of a guardian ad litem due to concerns over father's mental health. There is some discussion in father's brief, which I do want to address, about the lack of parent-child contact during the final 3 months of the case. And I think when considering this argument, it's important to remember that the operative parent-child contact order was the one in the disposition order, which only stated that contact between father and the child would be as agreed to between legal custodian and parent. That's at page 35 of the supplemental printed case. So the court was relying on the parties and their counsel to bring any disputes as to visitation by motion, like father did back in 2022 with his motion for conditional custody. But at no point following his release from New Hampshire custody at the end of 2024, between then and the termination, did father ever file a motion to modify that visitation order or to increase visitation. And it's clear from the transcript of the termination hearing held in April of this year, the department was trying to move cautiously so as not to traumatize the child or to disrupt her new placement. They consulted with father's counselor, who told the department that she was unable to recommend parent-child contact beyond supervised phone calls with father. So even if what DCF did in limiting contact after his release from the psychiatric facility was somehow improper, the appropriate modality of visits, at least per the counselor, was not one that would have shown father immediately ready to resume a full-time parental role. He wouldn't have gone from having no contact with his child since 2022 to full reunification. That's not how the trial courts handle these cases. There are incremental steps between those two extremes. So if the court wants me to respond to any other issues raised by father, I'm happy to. Otherwise, I would just thank you for your time and respectfully request that you affirm the judgment below.
Right, I don't see that there are any indications of any questions. Does counsel for the appellant have any time remaining?
Yes, appellant has 1 minute and 53 seconds remaining.
Counsel?
Thank you. While it is true that we're not disputing that over the course of the case there was stagnation, but there was a significant change late in the case, and the child still had no permanent placement. It's not, the burden doesn't shift to the father to create a reunification. Reunification should continue until the time of termination. And when there's a significant change on the ground, where it's clear that father is in significantly different circumstances and the child has no permanent home, that's not something to just be tossed out. I mean, this should have been met with celebration that now father could be a part of his child's life. And what the state is saying is, well, he should have filed a motion, because why would the government just agree that a child should see her father, who's now recovered, that she's been asking for, who's now recovered from a significant illness? So I would reject that burden shifting. And, to the extent that the state doesn't want to disrupt this placement, this is not the standard. A child's after-school activities, a child's, the school that the child might go to, those are not, and a family could move, right? Children change schools. These are not the things. The after-school activities are not what define a childhood. Children forget their after-school activities. Children don't forget their parents. When you terminate the rights of a fit parent with an established bond simply because he believes he can do it and doesn't have insight into his past delusional behavior, which we know was a medical issue, that does not serve Vermont children and is not in the best interest of children or families, and the decision should be reversed.
All right, thank you, counsel. Bailiff may call the conclusion of the case.